In the vast majority of DUI cases, when an individual is arrested, they have every right to drive unless they are convicted of that DUI. So while the case is pending, there is no restriction on your ability to drive. But there are limited cases where there is a restriction prior to a finding of guilt on the DUI or implied consent. Andrew, can you talk a little bit about some of those restrictions?
Sure. So, what we're often going to see is that if somebody is injured or if there's property damage, we're going to see the judge or the magistrate ordering that you only drive a vehicle that's fitted with the ignition interlock device. Now, that may work for the majority of cases, but we know that there are times where the ignition interlock device just isn't going to work.
Yeah, no, absolutely. And also, there's times when just because there's an accident, it doesn't necessarily mean that there was property damage to require the interlock under law. So, if it's a single vehicle accident where there's no property damage to another vehicle or to governmental property, such as a utility pole or a guardrail, then there's not necessarily a reason to have that interlock in place under the law. We can talk to the prosecutor or file a motion stating that it's not necessary under law. There's also other times where there are alternatives to the interlock when it does fit in that situation where you are required to have an interlock. What are some of those examples of alternatives to an interlock?
So, the number one that we see is the Scram ankle monitor device. So, that is not a GPS monitor, it's not tracking you. Is what it does is it monitors your sweat glands for the presence of alcohol. And that is a two-sided approach. A, it allows you to continue driving without having to have the interlock device. And B, it can have positive impacts on your case because it demonstrates to the prosecutor that you are maintaining complete sobriety, not just abstaining from drinking and driving.
Yeah, and the screen makes a lot of sense in that it's keeping the community safe, it's ensuring complete sobriety, but it doesn't necessarily sound great to a defendant, right? They're accused of it and required to have an ignition interlock, stating, well, you can't drink and drive, but you just talked about a scram where it's not just drinking and driving, it's no drinking whatsoever. So can you talk a little bit about why someone would potentially want that scram instead? Are there specific cases when it makes more sense to have that scram?
Absolutely. So if you were somebody that has some form of a driver's license or a job or a work vehicle or whatever it may be, that you cannot use the ignition interlock device. So if you're somebody who drives a commercial motor vehicle, if you are somebody who has a company work truck that you cannot put the device in, is the scram is a way for you to get around that condition that you can continue on with your current quality of life. You can continue going to work. You can continue driving to work.
Yeah, exactly. I mean, at the end of the day, an employer is not going to take the additional, risk of putting an ignition interlock on a vehicle they own. So that's where the scram, when you are required to put the interlock on a vehicle, might be an alternative that we can discuss with the prosecutor to avoid, the requirement of having that interlock on the vehicle. So we talked about when there's property damage. Also, if there's a child in the vehicle, you're required to have an ignition interlock, or if you have a prior, not just DUI, but a prior DUI, reckless endangerment, reckless driving, or implied consent violation conviction, then you're also required to have that interlock as a bond condition or scram if the prosecutor agrees to it. And then there's also other cases. So, for example, drug cases. Let's talk about those. We get a DUI with a prescription medication or an illegal drug in your system, required to have an ignition interlock because there's an accident or you have a prior reckless endangerment or reckless driving. Is there a way to get the interlock off the vehicle if this is alleged to be a prescription medication DUI?
Absolutely. You can always talk to the prosecutor about the fact that the ignition interlock device at that point is redundant. Is the ignition interlock device is only monitoring for the presence of alcohol. It's not going to pick up narcotics and it's not going to pick up your daily prescriptions. So what we do is in lieu of having the ignition interlock device, we talk to the prosecutors about doing drug screens that could actually detect for the presence of those things rather than making you pay and be fitted for an ignition interlock device that, quite frankly, just isn't going to serve any purpose.
Yes, exactly. At the end of the day, when we talk about bond conditions, we're talking about the least restrictive way to ensure the safety of the community. So if it's not a DUI case, there's no allegations that you were drinking and driving, but the allegations that you were under the influence of some type of prescription medication and driving. What purpose is there to put an interlock on that vehicle? It doesn't affect whether you're taking your medications as prescribed or not. That's where the drug screens come in as a potential alternative. So at the end of the day, when we talk about arraignments with DUI cases and bond conditions with DUI cases, we look at, well, how does the restrictions affect you, the individual, and how can we, change that to potentially benefit you as the accused?